Hello, and welcome to Canadian Rights Reviews, where we examine the ins and outs of Canadian rights, freedoms, laws, and policies. Today's video is an older one, from early 2016, and comes to us from the YouTube channel of Andrew McLean, who reported this incident is with the Saanich Police. Saanich borders the northern edge of Victoria, BC on Vancouver Island. It does not appear there was any follow-up, and the channel has been dormant for 3 years. However, all the relevant legislation covered for this interaction remains unchanged. Although not shown in the video, according to the text description, Mr. McLean and all his belongings were searched. He was accused of having fake ID and having outstanding charges in another province. His ID was collected and run, and the officer had the audacity to even quench his thirst by taking a drink from Mr. McLean's water bottle. It appears we can assume Mr. McLean was released after the incident, as the video was posted the same evening. The Canadian Charter of Rights and Freedoms guarantees many rights and freedoms. Today, we highlight 4. Everyone has the right to life, liberty and security of the person, and the right to not be deprived thereof, except in accordance with the principles of fundamental justice. Everyone has the right to be secure against unreasonable search or seizure. Everyone has the right not to be arbitrarily detained or imprisoned. Everyone has the right on arrest or detention, to be informed promptly of the reasons therefor, to retain and instruct counsel without delay, and be informed of that right, and to have the validity of detention determined by way of habeas corpus and to be released if the detention is not lawful. In our opinion, all 4 of these rights were clearly infringed upon in the video footage from Mr. McLean. However, we will primarily focus on the Section 9 right to not be arbitrarily detained or imprisoned, as everything else stems from an unlawful detention.
Me.
Sir, am I under suspicion of something?
Yes. I just told you we're checking everybody in the area. Grab some ID for me.
For what purpose? Why do you need my ID?
Why are you being so difficult?
Because I've done nothing wrong. Am I under suspicion? I know my rights.
I am stopping everybody right now. We have a fire just down the road. I am stopping everybody right now.
Okay, that's fine. You have a fire down the road.
If it was on your way home, you wouldn't be so difficult. Why are you being so difficult?
Because I've done nothing wrong.
Okay. Grab your ID.
You don't need my ID.
I am a police officer.
And I'm not legally required to show it on demand. I know my rights.
I'm investigating a possible arson down the road. It is my duty to
Am I under
ask you for
suspicion
your
of this
ID.
arson?
If you do not present your ID, I will charge you with obstruction. Do you understand that?
In the 2009 Supreme Court case of R.V. Grant, the court stated, "In cases where there is no physical restraint or legal obligation, it may not be clear whether a person has been detained. To determine whether the reasonable person in the individual's circumstances would conclude that he or she had been deprived by the state of the liberty of choice, the court may consider the following factors: A. The circumstances giving rise to the encounter as they would reasonably be perceived by the individual. B. The nature of the police conduct, and C. The particular characteristics or circumstances of the individual where relevant." To answer the question whether there is a detention involves a realistic appraisal of the entire interaction, as it developed, not a minute parsing of words and movements. At the very start of the video, the first question Mr. McLean asks the officer is, "Sir, am I under suspicion for something?" The officer responds with a clear yes.
Sir, am I under suspicion of something?
Yes.
There is no physical restraint, and clearly Mr. McLean does not feel under legal obligation at this time, but we feel it is exceedingly clear that an affirmative answer by the police to the question, "Am I under suspicion for something?" leaves no question that a reasonable person would find the individual is being detained. This point is being made for 2 reasons. 1. Often you will see videos where police state they are investigating suspicious activity and there is no actual related crime. In these instances, it is much less clear if an individual is being detained. In this case, Mr. McLean was specifically told he is under suspicion, and it was inferred fairly directly it was for the crime of arson. 2. This officer's default right from the outset is to detain people without reasonable grounds to do so. Violate first, ask questions later. In the 2004 Supreme Court case of R.V. Mann, the court ruled, although there is no general power of detention for investigative purposes, police officers may detain an individual if there are reasonable grounds to suspect in all the circumstances that the individual is connected to a particular crime and then that the detention is reasonably necessary on an objective view of the circumstances. The officer's own statements rule out any possibility of reasonable grounds being found here.
I just told you we're checking everybody in the area. I am stopping everybody right now. We have a fire just down the road. I am stopping everybody right now.
These statements, are a textbook definition of arbitrary detention, as per the previously mentioned 2009 case of R.V. Grant, where the court also stated, the officers acknowledged at trial that they did not have legal grounds or a reasonable suspicion to detain the accused prior to his incriminating statements. Therefore, the detention was arbitrary. If anyone is having trouble with that math, I'll explain further. If police are stopping and checking everyone, then they have no reasonable grounds to suspect a specific individual of being connected to a crime, and the stop is by default arbitrary. Although not our focus for this video, the language in this part of the court's ruling also includes, the right to counsel arises immediately upon detention, whether or not the detention is solely for investigative purposes. At no point in the video is Mr. McLean advised of his charter rights, Miranda rights, for our American viewers. For the Supreme Court, this must be done once an individual is detained. I just know some of you out there are thinking, but arbitrary stops must be legal. What about border crossings, and ID checks for buying alcohol, and DUI checks? Here is the difference. At the border there are A, national security concerns, and B, you don't have to agree to inspection, you'll simply be turned around and denied entry if you refuse. You don't have to ID to buy alcohol, you just won't be able to buy it. DUI or safety checks while driving, yes, you do have to comply, as the courts have long since determined driving is a privilege in Canada, and such checks do not unreasonably infringe on one's rights.
You'll charge me with obstruction for refusing to present my ID. Am I under suspicion of anything, yes or no? Why am I under suspicion?
I just told you, we're investigating a fire down the road.
You're free to ask me any questions you want about the fire.
Grab your ID for me.
Sir,
I'm not
I
going
don't...
to ask you again. The next time I ask you, I will put cuffs on you and arrest you for obstruction. Do you understand that?
Obstructing a peace officer. Very briefly, I wanted to point out the language of resists or willfully obstructs. In much of the United States, obstruction requires intent. This is not the case in Canada. In this case, as the arbitrary detention was unlawful, so was the demand for ID, which voids any obstruction charge for failure to ID. Moving on.
Why do you feel this is obstruction of justice?
Yes, you do?
No, I don't understand why you feel this is obstruction of justice.
Okay.
I see you're using your flashlight to obscure the video.
Put your phone down, otherwise it will go down hard when I put cuffs on you. Take your backpack off. Right now you're under arrest. Put your phone down.
I'm under arrest for what?
Obstruction, I just told you.
But I'm not obstructing anything.
You're not
I'm
giving
guilty
your
of
ID,
nothing.
You're not presenting yourself, so let's go. Put the phone
I'm
down.
not guilty of anything, officer.
Sir, put the phone down.
You're trying to take my phone now? Okay.
Okay.
Mr. McLean has now been thrown to the ground and arrested. Section 495.1a of the Canadian Criminal Code states, a peace officer may arrest without warrant a person who has committed an indictable offense or who, on reasonable grounds, he believes has committed or is about to commit an indictable offense. Okay, we don't know what the officer is thinking, and he may well believe Mr. McLean has committed an indictable offense, so nothing more to see here, right? Wrong. In the 1990 Supreme Court case of R.V. Story, the court held that it is not sufficient for the police officer to personally believe that he or she has reasonable and probable grounds to make an arrest. Rather, it must be objectively established that those reasonable and probable grounds did in fact exist. That is to say, a reasonable person, standing in the shoes of the police officer, would have believed that reasonable and probable grounds existed to make the arrest. This reasonable person thinks that other reasonable people would agree. If the detention was unlawful, then the demand for ID was unlawful, which would render an obstruction charge invalid, thus making the arrest for obstruction unlawful.
You touch me again, that's assault. Do you understand?
I didn't touch you. You were
I
trying
asked
to
you
grab
put the
my
phone
phone.
down.
You were trying to grab my phone.
Sorry.
My ID is in my wallet if you must have it then.
I know, folks, a lot of commentary on this one. Stick with me, we are getting there, and I do not want to leave unanswered questions. We see at the point Mr. McLean is arrested, he is wearing a bicycle helmet. We do not know if he was riding a bicycle, but I think it is safe to assume. In British Columbia, under the Motor Vehicle Act, Section 183, a person operating a bicycle has the same rights and duties as the driver of a vehicle. This means, if this is a valid traffic stop, Mr. McLean is required to ID, and everything covered so far is completely in error. It seems fairly clear to me, this is not the case. There is no language in the video at all to support this is in any way a traffic stop. Additionally, early in the video, we can clearly see a steady stream of unstopped traffic. We would not see this steady flow if a traffic checkpoint was set up as per the officer's statement of,
I just told you we're checking everybody in the area.
Wait, there is more. The Supreme Court has also addressed arbitrary stops, as I inferred earlier, stating, random vehicle stops constitute arbitrary detention, where the legislation authorizing the practice allows the police an absolute discretion on the selection of which drivers to stop. And, random stops may be capable of being justified under Section 1 of the Charter, if undertaken for the purpose of public safety on the highway. Where police are checking for driver sobriety, licenses, ownership, insurance and mechanical fitness. So, once again, the end result is an arbitrary and unlawful detention.
I have been assaulted this night, officer. I know my rights. If you want my ID, my wallet is in my back pocket.
Oh, now you have your ID. Perfect.
After you assault me, I have not threatened you.
Move.
I have not threatened you, officer. I have not threatened you.
Okay. Get flat on the ground for me. Get
Okay, it's hard to do that when you're on my back.
Get flat on the ground.
Officer, I am trying to follow your instructions, officer. I am trying to follow. You're taking my phone? Why are you taking my phone?
I don't want to have anything in your hands. I asked you for your ID when you're under arrest for obstruction. Do you understand that? Several times I asked you for your ID, right?
You gotta be kidding me.
It's on your phone. You can watch it again. You record the whole thing. You know.
Can you please let go of my arm, officer?
No.
I'm not threatening you.
Where are you coming from? Where are you coming from?
I'm coming from work, okay?
Where do you work?
I'm just trying to get home to my family.
Where do you work?
I work at Uptown Shopping Center.
I just want to go through on for email for me.
I'm completely innocent and I've been assaulted.
Lastly.
What is your badge number, please?
Charlie Lima Alpha November. If you want to enter your date of birth, 810516. Do you understand that you're under arrest for obstruction right now?
I understand that I'm under arrest for committing no crime.
Sorry? Oh. Did you pop off?
With all due respect, officer, this is completely unwarranted.
No, I told you several times. There's a fire down the road.
Okay, and I didn't dispute that.
It became extremely difficult.
I did not threaten you.
Okay, and you don't want to give me your ID? You have everything on your phone recorded, so you can watch it again. I asked you several times for your ID. I told you if you did not provide ID, you'd be under arrest for obstruction. Did you not hear that?
I'm
several times I told you that. Watch
question.
your phone because it's on the phone.
Okay, I am more than willing to answer any questions you have about the fire. I asked you, why do you need my ID to question me about that? I have done nothing wrong. I know my rights. This is an illegal act.
You should know your rights.
What you are doing is illegal. You have assaulted me, and I have not obstructed your investigation. You don't need to know my name to ask questions regarding a fire.
As noted earlier, Mr. McLean also reported his person and effects were searched. Considering everything to this point, the search, of course, was unreasonable and unconstitutional. Mr. McLean's conduct is approved. He was polite and patient, but stood his ground when it came to his rights, and asked valid questions. I would hope Mr. McLean followed up with an official complaint and potentially litigation, but that is information we do not have. Our unidentified officer gets a fail. I really don't know where to start except to say, I have now written 4 pages of single-spaced commentary, regarding rights infringed upon, based upon the first 2 minutes of this video. He could not be any more wrong. Granted, he was initially fairly nice, while trying to infringe on Mr. McLean's rights, but as the old saying goes, don't tell me it's raining while pissing down my back. We will update you further if we learn of any meaningful developments in this case. Thank you for watching, and we hope to see you again soon.